We do have some issues with regard to discovery and prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel, you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three such...
Hold on. I believe I said if you needed to raise the issue, you certainly could, but
We'd like to raise
do not
the
accept
issue.
that as a blank permission to redepose.
We didn't, Judge.
Okay, go ahead.
So we've been working to schedule depositions with the state, and for this morning, for the first time, we learned that they do object to us redeposing 3 of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands, and to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera with Ms. Adelson present to provide some information to the court as well on some attorney-client privileged information.
All right. This is going to need to be memorialized to the extent that you can in a motion. As far as any hearing that would occur in camera, I will make a decision on that, but first I actually need to read the basis of what you're seeking and why.
Now,
thank you, Judge.
with respect to Mr. Corbett, Your Honor, we haven't even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that was tentatively scheduled for May 14th, being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
Just going back and looking at the dates and the different cutoffs. 4:30 is the discovery cutoff by order right now. Ms. Dugan, as to providing Sergeant Corbett's presentation, why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive. And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were going to use, as far as everything substantive we were possibly going to use is in there. But you know, the final result might look better at trial and be formatted in a different way, but substantively it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available, and we'll continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown. If it's something that pertains to their client that's new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information that's already been said in prior depots, we would object to ask and answer and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was Agent Sanford and Corbett and Rob Adelson, that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera. but we would ask to have that done, be able to weigh in on that from our side as well in those same situations, and object to them being deposed again. If there is some new information in Corbett's presentation as of April 30th that they didn't know about before, we would absolutely be fine with him being deposed on that information, but just not having to go back through what's already been said with, hours and hours of depots and prior testimony.
All right. What I am not fine with is moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will, but there's still 2.5 months to that point, right?
Yes, sir.
We'll draft the motion, Judge.
Yes, sir. And, certainly, by way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that.
These trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor. Lastly, this morning I provided a proposed order to the court from the August 30th and September 6th motions in limine. I prepared those based on the transcripts that I had prepared of those hearings. I provided them to the state twice over the last month and had not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan, as the proposed order, is the state objecting to it, or you haven't had an opportunity to review it?
I did speak with Ms. Kaplan about that, and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. There are some additional motions to suppress and a handful of motions in limine. I'm hoping to get the motions to suppress filed in the next week to 10 days so that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
I believe the date that we're going to have for the pretrial motions, that was going to take place on Friday, May 16th. Obviously, more that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the motions that we are working on, we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for change of venue. I spoke with them yesterday, Mr. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set. Provide that to the court as well and get it set for a hearing.
All right. Concerning this report, and I'll leave this to your judgment, but do any of these matters need to be filed under seal to alleviate essentially the issue you're complaining of through the motion?
Yes, Your Honor.
Very well. Ms. Dugan, does the state have anything to raise today?
No, sir.
Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings on the motions, and we'll continue to move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess. Let's move on with calling the other matters this afternoon.
First, it seems that Donna is not concerned about throwing Dan Rashbaum under the bus. Her lawyers are requesting to redepose several people who have already been deposed by Donna's former attorneys, Dan Rashbaum and Alex Morris, including Sergeant Corbett, Special Agent Sanford, and Robert Adelson. The state is demanding that good cause be shown for the redeposition, especially, I presume, of Robert Adelson. The defense claims that the good cause for the redeposition will be shown through a demonstration of how deep the conflict of interest was in Dan Rashbaum representing Donna after having represented her son Charles Adelson. They requested an in-camera hearing, a secret meeting where the public and media are not present, where Donna would testify and expose attorney-client privileged information to substantiate this supposed good cause, to show how the supposed conflict of interest, which she had waived, by the way, impacted the effectiveness of the depositions taken by prior counsel. You may recall that Robert Adelson was actually deposed by Alex Morris, not Dan Rashbaum. Regardless, we won't get to see what Donna says at that hearing. The defense attorneys, Joshua Zellman and Jackie Fulford, also announced that they will be filing additional motions to suppress and motions in limine. They also have prepared for the court to sign several orders regarding motions in limine that were heard prior to the September trial of Donna, which never happened, of course, due to the conflict issues. Finally, on the issue of the defense motion to change venue, the defense announced that their media expert, who is compiling all of the one-sided pro-state coverage for the court to evaluate, will have a report ready soon, by early March, and the court asked that the report be filed in camera to avoid aggravating the very issue the defense is complaining about. The case is in high gear now. We are moving forward, that June trial date, full speed ahead, and as always, you can come to us for fair coverage. Thanks for watching. I'm Ed, not AI, Deep Dive True Crime. Donna Adelson, as expected through her lawyers, filed a motion to suppress the call. You know which call, of course. We played it for you here before, and we'll play it for you again here at the end of the video. It is the call where Donna was talking to Charlie not long after his conviction, while Charlie was still at the Leon County Detention Center, and about 8 minutes into the call, Charlie drops off the call, but the recording continues. The recording then grabs audio of Donna talking to others, primarily about Wendy Adelson, including a discussion of seeking her help in finding countries that do not have an extradition treaty with the United States. The essence of the motion is that the recording became illegal once Charles Adelson dropped off the call, and whatever consent Donna gave to be recorded while talking to her son ended then and there. This was, of course, an anticipated motion. This issue was discussed on this channel when the call first became public, but the grounds for the motion seemed lacking. Often, a motion to suppress requires an evidentiary hearing, particularly when facts need to be established in order for the court to make a determination of how to rule on the motion. In any motion to suppress, the goal is to have the court force the government to be fair in how it obtains evidence to discourage misconduct by the government. If the government intentionally violated someone's constitutional rights in order to obtain evidence, the defendant will then seek to suppress the evidence. Sometimes the government will argue that the error was unintentional, that the law enforcement officer was mistaken and acted in good faith. If that is shown, then the court may still allow the evidence. This area of the law is generally referred to as criminal procedure. The case law is complicated, and most rules and exceptions, and there are exceptions to the exceptions, and so on. But here, the way the motion is written currently, it seems that Donna's attorneys are relying on many facts as undisputed facts, without any apparent evidentiary support, and they're trying to avoid complex constitutional issues by relying primarily on the Florida wiretap statutes, in particular, Section 934.06, which provides for the exclusion of such recordings if the disclosure would violate any other portion of Chapter 934.06, which in other provisions prohibit recording without consent. In essence, Donna's lawyers argue that whatever Donna said after Charlie supposedly hung up or was dropped from the call is a protected, quote, oral communication, unquote, which is defined in the statute as follows. Oral communication means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation and does not meet any public oral communication uttered at a public meeting or any electronic communication. Thus, in essence, Donna's lawyers argue that she expected that the call dropped once Charlie could no longer be heard, and at that time her consent to be recorded ended. Thus, she argues, any consent she gave ended, and the recording became illegal in violation of Chapter 934 of the Florida statutes, and per Section 934.06, it has to be suppressed. If they're going only by the statute, the argument is not a bad one. When one listens to the recorded call, it is clear that at some point Donna realizes that Charlie is no longer responding to her, and then it does appear that she put her phone down and started talking to her guests about Wendy. We're not judges here at Deep Dive True Crime, but if we were, we would like to know a lot more about the actual facts before ruling on such a motion. 1. We would like to hear from Mr. Charles Adelson about what happened on his end of the call. Did he try to hang up? Was he using a phone or a tablet? Did he leave the phone call connected, pretending he was no longer there, and then tried to listen in on his mom? 2. We'd like to hear from the company that records the jail calls. What are the technical explanations for what happened? Did Charlie hang up? Would the recording continue if Charlie hung up and Donna didn't? 3, we'd like to hear from an expert for the defense, if the defense could contest what the company said about this, giving his or her explanation of what happened. And 4, we would like to hear from the other participants in that conversation, Harvey Adelson, attorney Susan Brotman, and Susan's husband, regarding Donna's supposed expectation that whatever she said would not be recorded by them. Of course, the counter-argument from the state, one of the primary ones, is likely going to be that she gave her consent for the call to be recorded, and that if she wanted to withdraw her consent, all she had to do was to ensure that she hung up the phone. By not hanging up the phone, the consent was still in effect, and the government should not be punished by the suppression of evidence only because Donna failed to properly end or withdraw her consent by hanging up the phone. This argument by the state would of course be much stronger if the jail calls recording company indicates that its system would end the recording if either side hung up the phone, and in this case, neither Charlie nor Donna properly hung up while the recorder was recording. If the system is glitched and continues recording after the person in the jail hangs up, then we would lean more towards suppression. We think the defense's motion would have been stronger if they had done the legwork with the company that records the jail calls and had determined the details of what happened here, especially if the system is glitched to continue recording even when the jail person hangs up, or is dropped off the call. The recording itself is quite important. The state even had the sound of that specific call enhanced. In it, Donna actually says that she believes that the call got disconnected. After that, she makes many statements that seem to be incriminating, even acknowledging that she may be arrested at the airport and that trying to leave the country is, quote, worth the shot. Regardless, whether this piece of evidence is suppressed or not, this is just one of many pieces of evidence that point towards Donna's efforts to escape to Vietnam, a non-extradition country. There are plenty of notes in her calendar. There is testimony of Scott Radius, and there is the potential testimony of the participants of that conversation in South Florida. There are her communications about obtaining a visa to Vietnam, and of course, there's the fact that she was caught at the airport with a one-way ticket to a non-extradition country. Our first impression of the motion is that it is too simplistic, but certainly the issues involved are interesting and complex. There's no doubt that Donna and anyone in proximity to that phone had no expectation of privacy while she was on the jail call with Charlie. There is no doubt that she thought the call ended. So the question for the judge is whether Donna's subjective belief that the call ended, without checking her phone to make sure the call had ended, was objectively reasonable. Another question is whether she did have any expectation of privacy when talking to friends about her plan to flee the country, whether that conversation was at home or not. We may do further analysis on this issue, but even if we don't, we certainly look forward to an interesting hearing on this motion, which may end up being an evidentiary hearing. In a sense, the defense motion to suppress raises issues similar to those regarding law enforcement efforts to obtain recordings by smart speakers like Alexa, which sometimes record even when a trigger wake-up word is not spoken. The motion is silent about other evidence that law enforcement obtained as a result of the leads, if any, that came from this recording, and whether such evidence should be suppressed. Okay, we will put a few links in the description for you, and here is the call. But we will jump in to just before the call supposedly drops from Charlie's end. On another note,
individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. Thank you for using Securus. You may start the conversation now.
Hey,
Yeah, sorry about that.
no, last thing I heard was you said, and the chief, and then it just went
No,
down.
he was supposed to fly. He's the same guy who always said he was going to call Dan back when I first got here. Never called him back. But Chief's back. He's the chief of the whole jail. So come by and check me out.
So
Once that happens,
he has not been there yet.
he has not, but the psychologist, PhD, whatever she is,
Yeah.
she came by and I said, listen, I'm fine. I'm getting claustrophobic. Like used to looking outside of a window, just out into the pod, and this is like here. You're sitting in like a
block.
Like a same kind of setup I had before, but I could look out the window into the pod. Here, it's like a box.
Yeah.
So you can't see. It's a mirror. They can see in, and you can't see out.
Is it any help? Can Dan get this guy to come sooner? Would that be of any help?
Chief Mac runs the fucking jail. He doesn't care about what we're calling. Right, it'll come slower.
Yeah. Well, I'm sure the psychologist thought you were fine. So it's just a matter of waiting for that and waiting for the chief.
Yeah, she has to run her report, and then it's slow, and then maybe tomorrow, I got 33% left on my phone, and in the afternoon. And it's okay, because once it hits the 15%, you switch the little battery saver on, and then I can probably get that. But it's like, you're just isolated. Like, I'm used to being able to talk to people, move around,
of course,
chat at myself. It's like, you're doing the complete opposite of what I would need to have done.
Right.
In this situation.
I know. All right. It sounds like if it's not today, they'll do it tomorrow, but hopefully today. But they're not in a rush, Charlie. You're in a rush. They're not in a rush.
It's like, it's bad enough all this happened. Now I'm like taken out of my normal surroundings.
I know.
Put into, like a solitary. I mean, I get why they do it. But this is like, it's trust me. This is the bed on like a plastic box. I rolled up my mattress upstairs and brought it down here, and it's just my bed sitting in my box, like a 3 feet by 6 foot box, put on the ground in the center of the room, where I'm used to walking back and forth in the middle of the now I just like walk up and then around the bed and then back.
And it's the same story with like they'll shut off the phones at 4 and not till 6:30 back on. Is that everywhere? Yeah.
And I'm
Hold on. Just checking in. Okay, there's Bree just checking in with me. Okay.
I talked to Dan.
Yeah. Then
and he's working hard. He's still in Tallahassee. I thought he had left. He's staying here an extra day, I guess, to write up. You know, so whatever it is, if they open up an inquiry, they ask the judge.
okay, good.
The investigation came on. You know, he said, "Look, it's maybe the kind of thing.
Yeah.
9 months from now, the juror writes something stupid on a blog, and they investigate, and they find out, like, and they find out something, and they're able to open it, and it could possibly lead to an appeal. You know, I basically got the judge let a lot of stuff in to the case, and he did that because he didn't want there to be an appeal. You know, the harder the judge rules, I guess there's more appellate issues that can come up, like if that guy, Hankerson or whatever. You know, I guess the harder the judge rules on issues that are in the trial, the more likely there is to have an appellate issue. If the judge is in favor of the defendant, the more likely there is to have an appellate issue.
Yeah.
You see what I'm saying?
Yeah, I do.
So, my general feeling, this is just my feeling, I'm not a lawyer, but my feeling is that he ruled, if anything, he gave us the benefit of the doubt because he didn't want there to be an appellate issue.
Yeah. Is that what Dan thinks?
Well, I mean, he made that comment to me that the judge ruled in our favor a number of times. You know, he let him bring stuff in. And I either said it or I heard it, that he meant it that there's not going to be, less things to say that were done wrong. I mean, you have to either say that the judge did something, then it gives you your due process. You know, if the jury didn't do anything improper, like, what's your reason for wanting a new trial?
If there was an appeal, would it have to be in Tallahassee, or can you move it? Because I don't understand why they wouldn't let you move the venue. I don't. It was blatantly, I mean, look, I have, I didn't say this to you before I picked up the phone, but there's a lot of things that we have to do, and we've got a very tight time frame. So one of them involves taking care of some things for Roman, taking care of some things through Steinberg. Dad's been on the phone all day, and Susan was nice enough when I called her. She said, I'm going to gather everything up, and I'm going to drive down. So she and Rick got here about, 10 minutes before you called, so that she could work with us, because we got a couple of hours of stuff to take care of for Roman. So, working on that, and just a lot, but you're going to be okay. You're going to get out of that stupid room. Once you do, you'll start to feel a little bit better. I know that. And when I have something that I do need to tell you, I'll speak to Dan. Okay? So, and then I'll let you know what time to call him. Can you hear me, Charlie? Shit. You can't hear me again, right? Charlie? Charlie, can you hear me? Can you hear me? I'm sorry. The fourth time that they cut the line each time. You have to pay for every minute, but they keep charging every time you reconnect. They say that doesn't happen. Listen, it's that he's in this room that they haven't moved. So the psychologist, they want to make sure he doesn't kill himself. So the psychologist finally came, and he said to her, "If you leave me here, I'll kill myself. There's no light, no nothing. I'm in a cement block. At least let me go back to myself and see where I am. Please, please don't leave me here." And spoke to him for a little bit. She said, "No, you're perfectly fine. I know that. I just have to go back and I've got a few of these reports I have to write. Once I get those written and then submit them and then get them approved, you'll be able to go back." So he thought he was going back like in an hour, but said that she better get that thing done because I'll lose my mind in here. It's all mirrored on the inside. So all you see is yourself. The lights never shut off, day or night. These fluorescent lights, he says, are on all night. He said, "I just want to go back where I was. At least I know people. I can see people. This is here. I'm in a box." So he's just... What? I'm sure he'll pull back and just keep getting disconnected. I didn't even know if he was drinking. He wasn't buying Coke. I ordered nothing. So I can try to my shoulders. Because we're under, I think, very tight time. Because I could have what? I don't want to. What I want to do. But it's not getting those of us. I think would be a nice way to just leave me alone and say goodbye. I am not with myself. And go to prison. He didn't do. I can't push it. I'm not that strong. And I also know how he, in a year and a half, his body and everything just slowly started to deteriorate. I'm old. I have a life. We had a great marriage. Happy. We traveled. We lived good. I really am not unhappy. And I'm more than willing to just say goodbye and let me lie down and go to sleep. It's nothing painful. I just want to go to sleep. We bought our cemetery property a couple of months ago. We're good. I'm good. But when did you this weekend? Because I said something that made her feel like I had enough and I'm not going to watch it over trial to go well. I know what I need to do. Now, something was wrong because we lived here 9 years. She's never once just come over and said, I need to talk to you. I'm sure probably sexual She sat down on the couch right there. I was sitting here, and she didn't say, "Look, Mom, this is a horrible time for all of us. Charlie's on trial for his life. We're all aggravated. But this is what you're thinking of. Just sat there. She said, "Listen, you're suicidal. I'm going to correct you." So I said, "I'm not suicidal. I'm fine. Will we see the boys tomorrow night?" Yes, Sunday night. She's the office. Good. Now, am I suicidal? No. Do I want to go to sleep and not see my son? I do. Perfectly honest, I do. And what we do it? We're going to do it together. Leave a note. They'll know when to come and get us. And we'll do it together. The boy. Look, got to make a decision at some point. So after speaking to Dan this morning and knowing what they're thinking up there, and I don't know if we'll make it out in time, I really don't. But Dan said, you might, or you might do all of it, get to the airport, and that could happen. It could happen. I don't know, but it's worth a try. I've tried and tried and tried. I don't know what I'm doing. I've lost it, but I don't know what I'm doing. And we have to look at stuff for Roman so that we can argue with that.
What do you think? How is it walking down?
With stipulations as to who's in charge and
got to Roman fell in a truck and where is it the guardian putting under as a trustee and some of the trustee as a guardian is the other then the trustee on
that somebody would be watching.
well, we want someone to take care of it, guardian of the person. So,
I would make some effort to respond after this call. If she would do that, I could sit here with you and say, would you do that? But I can't because no response. So, do you tell her that I could call George?
No, I don't get it.
I don't know how to get in touch with her. So I said, let me ask George. So I said, George, I can't get in touch with her. Bondage told me my lawyer to call her lawyer if it's about the case. And it was not about the case. I have been Lisa. Sure. When I said, I just got off with Charlie, he's worried about you. He wants to know why. Oh, because I said, yeah, we know you never ask anything about your brother. And she doesn't. And she told me it's because her lawyer said she shouldn't ask. But we found out it's not true. But we just got off the phone with him.
My attorney said no. And he asked her attorney. Her attorney said,
I never told her that.
but I've never confronted him.
No. So I wrote this last night. We know you never ask anything about your brother. This is 8:00 last night. But we just got off the phone with him, and the first thing he asked was, how's Wendy holding up? I didn't have the heart to tell him that you never called us or asked about him. I just said, we weren't up to phone calls right now. Everyone looks to protect you. I bet you've got a lot to think about. But then she didn't answer. But then I got another call from Charlie tonight, and I said, just got off the phone with Charlie. He's worried about you. He wants to know why we didn't speak. I told him a lie. I said, we're only speaking with you and Dan right now. I couldn't bear to tell him the truth. Your sister never even called us, is the truth. So she says, this morning, I thought she'd be racing over here last night. Yeah. Dear Mom, I know you are upset by the verdict, but the anger directed at me is not justified. I don't know how much anger we don't. I'm not responsible in any way for Charlie's situation. I am not guilty because I did not do anything wrong, and I was not involved in any way with Danny's death. Here she was. When I was interviewed by the police and testified in court, I told the truth, as I was required to do. I cannot control how the prosecutor used my statement at Charlie's trial. Again, I didn't say that. Also, as you know, my lawyer has advised me not to talk to my family or anyone else about this case. No, about the case, which is true. We've never done it. I followed his advice despite your disagreements with this guidance. Please do not text me about this case anymore. Not about the case, is it? Not what I said. About her brother, and that he wants, how are you, Wendy? How's my sister holding up? She can't. If you have anything further to say about the case, please go through our lawyers. Right now, I have to be singularly focused on taking care of the boys during this difficult time. So I wrote back, okay, we have no desire to speak with you about the case. I guess Dad and I are just shocked that you didn't think of coming to see us or even calling us. We are your parents. We are and have always been there for you and the boys. None of what we wrote matters about the case. That's over. I just want you to know how many times Charlie is asking about you. Not only do you not ask about us, but not one question about Charlie, right? We will need to give you some information shortly, and we need some business assistance. Please let us know if you can be of any help. I have a space here. I want to give her pose. We're going to be gone. I want her to have all this information. I have the cemetery property. I want her to see all that. I want her to have all these papers and the wills. I want her to see all this. So please let us know if you can be of any help. The other thing is the visa, which she would know about. But no, I said we need some business assistance. Please let us know. If not, we'll try to find someone who can help us. This needs an immediate reply so I can start asking other people to help. And then she always gets nervous if we want to talk to her. So I wrote, don't get nervous. Again, nothing, in capital letters, nothing about the case. Just would like to show you some business stuff and personal things. If you can't do it, we must find someone who can. I hope you understand that it has nothing to do with the case. There is no more case. And then I wrote, by the way, you said you have to focus on the boys. Have you told them? So when I got George before, I said to him, because I was over there last night, I said, well, I asked Wendy, but I haven't gotten any word from her, so did she tell the boys? And he said, she did. Now, I know Ben was very close. He was writing to Charlie all the time. So I said, how are they? Ben was very quiet. He didn't really talk much. He said, we can kind of face it and said, so he's never coming home. He's never coming back. And so he said it took him 10 minutes and he was into basketball. I said, fine, he's a child. That's okay. I don't want to see them miserable and upset. That's not my goal. I just want to know how are they. So that's what I said earlier to George, because it was technical stuff that I couldn't do on the computer, and it just was, we were out of it. So, and he's a computer tech person, so I said, can you help me with some computer stuff that I can't get done? And he was on some business calls, so that he texted me just before I can be there, maybe 5:30. Would that be good? I said yes, but if I can get stuff done, then it's no.
I told Rick to have the space of the passport.
We'll have the photos. We have to get them downloaded. And the other thing I don't understand, how my daughter could help me with, but we've been looking it up over and over, because things change if there is extradition from Vietnam. Because we've looked at all the places. I mean, I could go to Korea and China, but there's no extradition. But we're looking for places where there's no extradition. Oh, really? Good. Maybe she knows about. Maybe she can look up the extradition issue before we waste our time.
Is she going to tell on you that my parents are thinking of leaving the country?
My lawyer told us to do that.
Okay, but if you mention it to Wendy, is Wendy going to tell somebody?
Well, you tell her beforehand. I need to tell you something as an attorney who doesn't talk and has nothing to do with the case. It just has to do with Mom and I and some decisions that we have to make. Yeah, I know you want to bring her up and show her where everything is. If the plane crash, no one's going to know where anything is or who belongs to what. So I would like her to come up here so she can see it. I don't think that's asking too much. She can live 3 hours away. Every time she says, can you do this? Can you come here? Can you do this? Everything. How many times do we have plans that I really can't? I have to cancel. Wendy needs us for this. Wendy needs us to babysit. So we've been really good nannies, and I guess our job is up. Because now the boys are older, they can go out with friends, they can do things on their own. So she doesn't need grandma and grandpa. Okay, pretty hurtful. I have one son that I don't speak with. I have one son who's close to being dead. And my daughter, whom I love, is doing this. I don't get it. I don't get it. I said to Harvey, I swear to God, our family was cursed. Absolutely cursed. And I don't know how to take care of it anymore. So. address to put on the visa. Nobody knows where we are, right? Just some address on the visa, right? Look up. Whenever it's under my position, when anything there's just one a place that I could when did it tell you what the prices are? Do I have to go on to school? I'm sure it's right. Oh, you have to go on this. Yes. This one is it's called an my daily trouble.
Donna also filed a motion asking the court to release her on bond, requesting an Arthur hearing. We will discuss that at a later time. The hearing on that motion will take place on February 26. Thanks for watching. This is Ed, not AI, Deep Dive True Crime.